Hi, everyone. I'm Kara Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. And I like to dive right in. So, the very first thing I want to talk to you about is the travel authorization document, otherwise known as advance parole. We have been getting reports, and Immigration Service is aware that the lockbox has been erroneously rejecting advance parole applications and opening up medicals. So, if your advance parole application has been rejected with the rest of your application, um, you can now, because the Immigration Service has realized that there is an error that they need, probably a training issue that they need to fix at the lockbox, you can actually just simply refile the entire application, especially with the advance parole application and also the medical. You do not have to go back to the civil surgeon and have the medical redone and resealed. You can return it as is. That said, make sure that that is the only thing that was incorrectly returned with the application. For some reason, we are seeing the medicals being returned with the advance parole documents. Not sure why. Again, it kind of sounds like a training issue, but immigration is aware of it. So if you are getting those back and you think that you should not be getting it back, just make sure that that's the only thing that seems to be wrong, and then you can just return everything back to the Immigration Service, and you do not need to get a new medical resealed by the civil surgeon. But I will keep you up to date on that and see how that issue goes. Hopefully it will be resolved quickly. The second thing I want to remind you of, and this is really just more of a reminder, if you've been listening to me Monday mornings, you've heard me talk about this a little bit. Your I-94 card. When you enter the US, you are stamped in for a specific amount of time. It used to be that you were given a physical card that had the date by which you needed to leave the US. Then they did away with the card and everything is now electronic. So just make sure that immediately after you enter, you go to the website and check and see what your actual status is and the date by which you must leave. If there was an error in that information when it was uploaded, it is much easier to get that error fixed sooner after you enter rather than later. So things that we have seen in my practice are individuals that should be in a work authorized status or accidentally admitted in visitor status. Sometimes it happens. We are all human. We are all fallible. We all make mistakes. So you just want to go online and make sure every single time you enter the US, go online, pull down your own I-94 information and make sure that you were stamped in properly. And if you were not, there are certainly ways that we can go about getting that remedied and fixed with CBP. The next thing I wanted to talk about is Florida Senate Bill 1718. This has been in the news quite a bit. It's going into effect July 1st of this year, so July 1st of 2023. It's a new law. It impacts only the state of Florida, so this is not federal law. It is just for the state of Florida, but it will require, as of July 1st, all employers with 25 or more employees that are in Florida to use E-Verify to check the employment eligibility of their newly hired employees. This particular law also imposes civil as well as criminal penalties for employers who knowingly hire individuals to work for their companies that do not have employment authorization from the federal government. So if you're not sure what E-Verify is a federal system where when you hire someone, you can plug in information into the E-Verify portal that you've set up with your company, and then E-Verify pings off of Social Security Administration as well as Department of Homeland Security databases to look for your new employee to make sure that they have work authorization. There is a whole process, which is part of E-Verify, that all employers go through if there is what we call a non-confirmation, meaning there is a mismatch between the information that you as the employer input into the system, that information is given to you by your employee, and what is on record with the federal government. And so now Florida has said very broadly, employers with 25 or more employees must use E-Verify on all of their new hires. So if you're not quite sure how to use E-Verify or you've got some questions, feel free to reach out to my office, 954-903-1337. This is fairly significant here in the state of Florida. The other thing coming out of Senate Bill 1718 in Florida is that this bill, again, which will be effective July 1st of 2023, now prohibits in Florida the recognition of a valid out-of-state, so a valid non-Florida issued driver's license that was issued to an individual that is in the U.S. but is undocumented. It also this bill also requires healthcare agencies, hospitals, to collect certain data regarding the immigration status of the patients and to report that data back to the state. So these are three fairly significant things in this bill that will impact employers and how they interact with immigrants in the state. We, as immigration professionals, do suspect that there will be litigation on this. If there is, of course, I will keep you up to date on that, but I wanted to let you know that that is out there. It has been signed and it will become effective beginning July 1, 2023. If you have any questions about that, in terms of your I-9s, your E-Verify, driver's license acceptance, feel free to give my office a ring and we will help walk you through that. And y'all know it's still H-1B season, right? So I'm still going to talk about it just a little bit. And I know y'all are really tired of me talking about it, but that's okay. I'm going to keep talking about it till it's kind of officially over. And then I'm going to talk about it again next year. So all H-1B cases, if in fact you were selected via the lottery, those cases must be filed by June 30th of this year. So we are coming up against in the next month that deadline. So if you haven't started your case, you have plenty of time to get it prepared and filed, but make sure that that case is filed by June 30th, 2023. Super fast today on H-1B cap. The last thing I want to give you or talk to you about is another national interest waiver tip. So as we know, if you have been listening to me, I've been giving y'all national interest waiver tips. National interest waiver is one way that an individual can apply for a green card to live in the United States indefinitely. So the national interest waiver category, you must show that your proposed endeavor, what you want to do for work, your career path, has both substantial merit and national importance within the United States, and that you as an individual are well positioned to flourish and move forward your proposed endeavor within your career. And that, kind of on balance, it would be beneficial for the United States to waive the regular requirements of a job offer and advertising for your specific role in the United States. So the tip that we have today, or the tip that I have for you today, is that I get this question often. There is no set industry or list of industries that will automatically qualify you for a national interest waiver green card. That list just doesn't exist. The Immigration Service does not have a list. They have not published a list. It is not part of the rule. whereby if you are a part of a certain industry or you have a certain job or a certain profession or a certain career path, that you are guaranteed to get a national interest waiver green card, or even that your odds are better. At the end of the day, your application must show that you meet the criteria. And those criteria, again, are that your proposed endeavor has both substantial merit and national importance, that you are well positioned to advance in your career in the United States, and that on balance, it is beneficial to the US for the US government to waive the usual requirements of having a job offer, meaning having an employer sponsor that green card, and going through the labor certification process, which requires an employer to advertise for the position. So it doesn't matter what your career path is or what your industry is, you must meet that criteria. So there is no set standard list that we go from. But you really need to be able to show substantial merit and national importance. And to qualify and to show that, it's a very document heavy application. So we must provide the government with evidence, with documents that show that you meet those requirements. And so that is my tip for the day for national interest waiver. It does not, there is no, one size fits all in terms of industry or category of work or job title or job position. We just have to make the best argument that we can and give them the documents. So that's my national interest waiver tip. And that is all I have for you all this morning on Beyond the Soundbite. If you have any questions, feel free to pop those in the comments below. You can also subscribe to this if you are watching on YouTube. Feel free to like and share with colleagues if you have found this helpful. And as always, if you have any questions, feel free to reach out to the office, 954-903-1337. We'll get you set up with a consultation. And have a wonderful Monday and a great rest of your week.